Hi, welcome to Valorum Damus educational video. Today we'll be talking about authorized cause and just cause. Are you a regular employee but got terminated without a valid reason? Under the principle of security of tenure, a regular employee cannot be dismissed without a valid reason. Labor Code, P 442, Article 294. Employers must provide proof and a valid legal ground for termination. Termination by an employer is only allowed under the following grounds. Just causes. Just causes refer to blameworthy acts committed by the employee. Labor Code, P 442, Article 297, including serious misconduct or willful disobedience, gross and habitual neglect of duties, fraud or breach of trust, commission of a crime against the employer, and other similar violations. An example of termination for just cause is the case of Agabon v. National Labor Relations Commission G. 158693, November 17, 2004. In this case, the Supreme Court ruled that the employees abandoned their jobs, which constitutes a valid just cause for termination under Article 282 of the Labor Code. The court found that the petitioners engaged in subcontracting for another company and deliberately failed to report to work, demonstrating a clear intent to sever the employer-employee relationship. Note: for just causes, the twin notice rule applies. G. 164662, February 18, 2013. First, a written notice specifying the ground for termination and giving the employee a chance to explain. And second, a termination notice issued after due process, confirming that grounds for dismissal have been established. Authorized causes. Authorized causes refer to lawful grounds for termination that do not arise from the employee's fault or negligence. Labor Code, P 442, Article 298 to 299, such as installation of labor-saving devices, redundancy, retrenchment to prevent losses, closure or cessation of business, and incurable disease, not curable within 6 months, as certified by a public health authority, and continued employment would be harmful to the employee or coworkers. An example of termination for an authorized cause is the case of Veterans Federation of the Philippines versus Montenegro et al., 184819, November 29, 2017. In this case, the Supreme Court ruled that the cessation of business operations is a valid authorized cause for termination under Article 298 of the Labor Code. The court found that the employer genuinely ceased operations in good faith, properly notified the employees, and provided the required separation benefits, making the termination lawful. Take note that the employer must serve a written notice to the affected employee and the Department of Labor and Employment, DOL, at least 30 days before the intended date of termination. Unjustly dismissed? Know your rights. Got questions? Drop them in the comments below. Disclaimer: this is for informational purposes only and not legal advice. Please consult a legal professional for specific concerns. Thank you for watching. Please like, share, and subscribe.